Ladies and gentlemen of the jury, the court now charges you as follows. Plaintiff in his petition avers that on the 21st day of May 1967 at about the hour of 3:30 o'clock in the afternoon, he was driving an automobile truck and stopped on Howard Street in the city of Akron near the west curve of said Howard Street. That while his truck was thus standing still, a bus of the defending company struck the rear end of his truck, throwing the body of the truck forward and inflicting in that manner the injuries of which he complains. He also avers that as a result of the collision, the truck was itself damaged. Now, the court says to you, in that connection, in your consideration of this case, you are charged that the plaintiff has withdrawn his claim for damages to his truck. He says that the collision that occurred between the bus and truck was proximately caused by negligence on the part of the bus driver, who was then and there operating the bus. He avers that the driver of the bus was negligent in that he ran the bus at a rapid and dangerous rate of speed, to wit, 45 miles an hour, that the bus driver failed to keep a lookout ahead, that the bus driver failed to give notice of the approach of the said bus to the point of the accident by sounding a warning with his horn, that there was an unobstructed view from the point where the driver of the bus was traveling on Howard Street to the point where the truck was standing, and that as a result of the collision, the plaintiff suffered the injuries which are particularly set out in the petition. And the court says to you that since the plaintiff has withdrawn the claim for any damages to his truck, in no event can the amount of recovery exceed the sum of $20,000, the undisputed evidence being that the damage to the truck was $1,160. And to the amended petition of the plaintiff, the defendant filed an answer in which it admits its corporate character, admits the occurrence of the collision, but denies all of the allegations of the amended petition, which charges negligence upon the defendant company or the driver in charge of the bus in question, and avers that the collision between the bus and the truck was occasioned by negligence on the part of the plaintiff, that the sole and proximate cause of the collision was such negligence on the part of the plaintiff, that as the bus approached the point of the accident, the plaintiff caused his truck to move backward and thus brought it into the path of the advancing bus, and that was the sole and proximate cause of the collision. That if the negligence of the plaintiff or the acts of the plaintiff were not the sole cause of the collision, then in that event the accident was contributed to by the negligent acts of the plaintiff. To the amended answer, the plaintiff files a reply in which he denies all of the affirmative allegations contained in the answer. Now, these are the pleadings in the case, ladies and gentlemen of the jury, and present the issues which are to be submitted for your determination. They are not, of course, to be regarded as evidence. They are merely taken as setting out the claims of the parties to this litigation. You will observe that certain matters set up in the petition, or the amended petition rather, are admitted in the answer. Whatever allegations are set out in the amended petition and admitted in the answer may be taken as true, but you will observe that as to all statements or allegations of negligence on the part of the defending company, a denial is interposed. And the effect of this denial is to put upon the plaintiff the burden of establishing the truth of the matters thus denied by a preponderance of the evidence, that is to say, by the greater weight of the evidence. This does not necessarily imply that the plaintiff shall bring a greater number of witnesses than are brought by the other side, but it does mean that the net effect of the weight of the evidence must preponderate or be of greater weight in behalf of plaintiff before he can recover. If the evidence is equally balanced, or if it shall be found to preponderate in belief of the defendant in either of these last named cases, the plaintiff would fail in this particular cause of action, because under the issues in the pleadings as they are presented in this case, the plaintiff has the burden of proof. The action is founded upon alleged negligence, which alleged negligence, it is claimed, approximately caused the injury to the person of the plaintiff. Now, negligence, ladies and gentlemen of the jury, may be defined as the want or absence of ordinary care. Ordinary care is such care as men of ordinary care and prudence are accustomed to exercise under the same or similar circumstances. It is claimed in behalf of the defendant company that the plaintiff himself was negligent, or that if his negligence was not the sole proximate cause of the collision, at least he was guilty of what is called contributory negligence. Contributory negligence may be defined to be any act or omission on the part of the plaintiff amounting to want of ordinary care, which, combining and concurring with the negligence of the defendant, becomes the proximate cause of the injury complained of. And the burden of showing contributory negligence as a defense would rest upon the defendant unless Now, the evidence introduced in behalf of the plaintiff be of such character as to raise a presumption of such negligence on the part of the plaintiff. If you so find, that the plaintiff would not be entitled to recover. By bond. Now, in November, before